All right, so this is the landmark case establishing the doctrine of the separate legal corporation, personality of the corporation. Although the UK companies legislation had already established this principle, the problem that you had in the UK was there were many judges that were as you can see in the lower court decision in this case as well. Many judges were actually applying principles of legal realism and bringing their subjective assessments into the picture and not strictly following a formalistic application of the of this doctrine of the separate legal personality. So this is a case which is the House of Lords case, which is the highest court in the UK at that time, which has laid down emphatically this principle. As you can see, the judges are very formal approach to reading the law. So what we'll do initially is we'll just go through the particular questions that you had asked. There's actually a lot to learn in this case, and we'll try to cover. Initially we'll cover, because there are many aspects of finance that you can study from this case as well. So the objective is always to study everything from an interdisciplinary perspective, mixing up finance, law, HR, all kinds of domains. That is the kind of skill set that an MBA needs to have, a multidisciplinary approach to every problem. So we'll try and do that, but unfortunately because of limitations of time, we have not had the opportunity to do that here. So first I'll just answer the particular questions that you were asked, and then if we have time, we'll go into many of the other aspects of the course of this case that can be studied. And if we can't cover everything, I'll release a longer video which I had recorded last year in my office, which is not time bound. So it's a much more comprehensive video. You can watch that if you want to learn more about it. Okay, but your syllabus is essentially what we cover in the class, right? So whatever is the official video for the class that is uploaded, that's your syllabus. So it may be your section video, or it may be the other section, because sometimes if you're not the last section, then your video is not recorded. So you have to go with the recorded video for each session. That's the official syllabus for your for your course. Okay. So first question: why should Mr. Salomon not be held liable? We'll actually answer all three kind of simultaneously. As you can see here, the court, obviously this is an example of formalism. The court takes a very formal approach to the a strict interpretation of the law, and so what the court sees is that when the company is properly formed, it just checks the boxes to see whether the company has followed all the requirements of the Companies Act in the UK, and it sees that there is nothing there which talks about shareholders can't be related, that you have to hold more than one share. No such thing is mentioned in the Companies Act. So therefore, all these allegations that are leveled at Mr. Salomon, the court shoots them down because it says that these are not mentioned in the legislation, and so we are not concerned with these aspects. Okay, as far as we are concerned, there is no proof of any kind of fraud in the incorporation of the company, and it is completely properly formed as far as the requirements of the statute are concerned, and that is all that the court is concerned with. So straight away you can see that the court is taking a highly formalistic approach to the interpretation of the law. And you can see once again in the case of fraud, there is a mention of a particular case. If you see towards the end, one of the lawyers, the counsel for the company, this is actually, the case is being brought. Salomon as the individual is suing the liquidator for Salomon and Company. So if you look at if I give you the longer presentation, I've talked about the procedural posture of this case. This is actually a very complex, if you look at the technical aspects of procedure, this procedural posture of this case, like where has this case come from, which courts has it come through, then what is the issue in this case, those things are what we call the procedural posture of the case. So that is also quite complex actually. But so in this case, what is happening is that the liquidator of the company is bringing the case against Salomon. He brought the case against Salomon, and Salomon lost in the lower courts, and then he's come to the House of Lords. This is Salomon, the individual, suing the liquidator for that company. So that's why the defendant is the company itself. So the defendant's counsel actually has said that they have mentioned this case of Erlanger versus New Sombrero Phosphate Company. Now this is a case where there was some element of fraud. There was improper disclosure. I mean, they did not disclose the actual facts to the future investors of the company, and then they sold the company to this group of investors who were given the wrong information essentially. So there was clear fraud in the example in this case. Okay, so when the defendant's counsel presents this case as a precedent to be followed. So remember, try and connect it with all the legal theory that you have learnt. When you're fighting a case in the court, your counsel is going to try and argue with respect to statutory principles and also with respect to precedents, especially in common law countries. So the defendant's counsel, the defendant here is the company, that is the liquidator for the company, who's trying to make Mr. Salomon, the individual, liable for the debts of the unsecured creditors. So what he's trying to say is, hey, look, there was this case, Erlanger versus New Sombrero, we just call it Erlanger. There was a case of fraud in that instance, and then the court actually, in this case, what happened was the court held the promoters of the company liable for the monies that were to get paid up by the new investors who were defrauded. So therefore the counsel for the corporation is actually saying that we should follow the same precedent in this case. Here also there is fraud involved, and Salomon has just used the company as a front to carry on his own business. So we should follow this precedent and rule against Mr. Salomon, the individual. But the court actually says, no, this is not, the court engages in what we call, so the court shoots down this precedent. It says that it's not applicable. Why? Remember, when we discuss something, when we discuss legal theory, we discuss distinguishing. So whenever a court says, so because if the counsel has brought up this case, the court will have to address it. They can't ignore it. They will have to address it. If they throw up this case as a precedent, the court will have to address this case and say either that it applies or it doesn't apply. In this case, it says that it doesn't apply. Why? So whenever the court says it doesn't apply, that is a case of distinguishing. Okay, whenever the court says that a certain precedent cited by somebody is not applicable, that's a case of distinguishing. Now, distinguishing, as you know, can be of two types. Okay, which we covered in your legal theory module. It's either restrictive. Now we don't have enough time to go around the class and do a seminar style discussion on, okay, what do you think, what is non-restrictive, what is restrictive. So I will do this just as a lecture tutorial style. So I'll just tell you that, but you should be aware of all these factors, right? That distinguishing is of two types, restrictive and non-restrictive. And this is a case of what kind of distinguishing?
Non-restrictive.
Non-restrictive, because it's written there in the answer itself, right? So why is it non-restrictive? Because remember, this restrictive, non-restrictive, this applies to the ratio of the precedent that is cited. So this is non-restrictive because here the court is not seeking to cut down the ratio of Erlanger. They're not saying that the ratio of Erlanger was too broad. Unlike the situation where we talked about, a judge in NUS ruling that all DSB students should be debarred, and then you went and argued and said that this ruling is too broad, only the male students should be debarred. So that was a case of restrictive distinguishing because you are trying to cut down the ratio of the precedent. Here you're not cutting down the ratio of the precedent. This is non-restrictive distinguishing, which is not restrictive of the ratio of the precedent. Therefore, it is based on the factual differences between the two cases. So here, what is the court is doing? Court is doing distinguishing based on facts, and the court is saying that Erlanger does not apply because in Erlanger there was actual fraud involved. Here the court is saying that here in this case there was no actual fraud. All right, there is no proof of fraud in the case of Salomon. Everything was disclosed to everyone concerned, all the shareholders. Okay, and it follows all the rules of the Companies Act. And therefore, we have to treat this as a separate entity. So this idea of the corporation being a separate entity, which is part of pretty much every country now, the company law in every country. Okay, so the idea here, and then understand also that as a general principle, so we can answer the corporate veil part of the question also, which is that the corporate veil essentially is what exists between the company and the shareholders, right? So in this case, and the default, remember that in most countries which follow this model of corporate law, the default approach is not to lift the corporate veil. You understand what default is?
Yes, sir.
Default means not. Default has another meaning, which is in this case the company has defaulted on its debts. That is one sense of default. Here the default option, what I'm talking about, let's say your smartphone, if you don't do anything to the brightness setting, maybe the default setting is 50%, because there has to be some value for the brightness, right? So the programming of that smartphone is that if the user doesn't change it, the default will be 50%. Then if you want to change it, you change it. So the default in company law is that the corporate veil will not be lifted. Because the purpose of corporate legislation is to provide that protection to the members of the company. The shareholders are also referred to as the members of the company. So the default is not to be lifted, and so you have to show that there is enough of a case for lifting the veil. Remember here, when your readings we have talked about lifting the veil means essentially treating the shareholders and the company as one. Okay, and if you don't lift the veil, you treat them separately. So the default is that the court will not lift the veil by default. If you want the court to lift the veil and treat Mr. Solomon and Solomon and Company as one, then you will have to show to the court that there is some reason that has been satisfied, some judicial reason or some statutory reason for lifting the corporate veil that has been satisfied. So remember here there's a question of burden of proof, okay, which I don't know if I've mentioned burden of proof here, but I think here we can just briefly mention that. So default is, I'm just writing it, by default, okay, veil not lifted. I'm just writing shorthand here, but since you're in the class, you should you know what this means, okay? Now, there's this concept of burden of proof which you should understand if you're in since you're doing a business law course. In any case, if you remember your self-study, in your unit 1 on jurisprudence and legal theory, I've given you some self-study materials which many of you have not probably read, but one of those topics in the self-study materials is standards of proof. Okay, standards of proof, and so there are 3 standards. In criminal law is beyond reasonable doubt, and in civil law you have with a preponderance of evidence, a preponderance of probabilities, or clear and convincing evidence. So clear and convincing evidence is halfway between the two. All right. So now this is connected to the idea of burden of proof. Burden of proof is according to our Evidence Act, the burden of proof is it lies on he who alleges a fact. So if the police are now going to arrest Harsh, let's say for, if the police are going to arrest Harsh for some kind of theft, let's say, then Harsh does not have to prove that he did not commit the theft. The police have to prove that he has committed a theft, and they have to prove it because it's a criminal offense, so they have to prove it beyond a reasonable doubt. So this is what is, so here we say that the burden of proof is on the police. The burden of proof is on the prosecution. He does not have to do anything. That's why in many criminal trials you see the defendant doesn't even testify, because they feel that the prosecution has not satisfied the burden of, has not met the standard of beyond proving the allegation beyond a reasonable doubt. This is clear. You understand what burden of proof is. So in India, burden of proof, pretty much in every other country also, lies on he who alleges a fact. So if you say something, you have to prove it, right? Lies on he who alleges a fact. So in this case, what we are discussing here, why are we discussing this other legal concept? That if you are going to go to the court and say that Mr. Solomon and Solomon Company should be treated as the same, that means you're asking the court to lift the corporate veil. That is not the default posture of the court. So the burden of proof lies on you to prove that one of the either the judicial reasons or the statutory reasons for lifting the corporate veil has been satisfied. So you have to show that there is enemy character or tax evasion or avoidance of welfare legislation or something or the other is going on here, which requires the court to lift the veil. Otherwise, the court will not lift the veil. So in this case, the court says that there is no such case. Okay, so essentially the court is therefore going with the default option, not lifting the veil, treating the company and the shareholders as separate entities. And then here what they are saying, therefore the debts, because the company is a separate entity, the debts are the debts of the company, not of the shareholders, right? And so therefore Mr. Solomon is not liable as a shareholder for the debts of the company. And the other thing also is that when the unsecured creditors, which is also an important point, that the unsecured creditors, when they were dealing with the company, they knew that the company it was a limited liability company incorporated under the UK Companies Act, right? So therefore there is something which we may not have time to study. There is something called the doctrine of constructive notice. Okay, this falls under the general idea of a constructive doctrine of constructive notice, that you know that a company has limited limited liability, you're aware of all the documents involved with the filing of the company and the company's law. So you are supposed to be aware of these facts, right? So limited liability, let's also clarify. Everybody was not clear about limited liability. I've written it down. By the way, all this stuff I'm going to paste into your notes, so there's no need to take note of any of this. The discussion on this case is actually very long. I don't know how much we'll have time to cover, but all this will be pasted into your notes. Most of it is, these are extract from the Dutch judgments to show you that this is example of formalism. Okay, where is limited liability? Yeah, so when we use them, some of you did not use it in the right sense. When we talk about limited liability companies, right, understand what limited liability refers to. So obviously somebody's liability is limited. Whose liability is limited? It is the liability of the common shareholders or equity shareholders. What we call in Indian law, we call it equity shareholders. Okay, in the US law, we call it common shareholders. The liability of members of so these are also called members. Okay, so when we talk about limited liability, understand that in the law we typically refer to the shareholders as members of the company. We don't actually say owners. The term owners is used in when you look at finance textbooks, you'll see in finance we refer to the shareholders as the owners of the company. But in law books we normally don't do that, because the company is a separate entity. They don't own the company. The shareholders are actually the members of the company. Okay, or at the most you can say they are shareholders of the company, equity shareholders. So there's an important difference in the way we refer to shareholders in finance literature and versus the law literature. Okay, so the law literature is the correct approach actually. So okay, so the liability of, so what we say here is when we're talking about limited liability, it is the liability, so Harsh had mentioned this correctly, that the liability of the members of the company is limited. In what way? It is limited to the amount of shares subscribed to but not paid up. Okay, because you have already paid up certain amounts, so there's no liability as such because you have paid it into the company. So when you're talking about limited liability, you're talking specifically about the difference between number of shares, value of shares subscribed to minus value of shares paid up. That is your liability. Okay, and your liability is limited to only that and nothing more. Right, so the shareholders, the unsecured creditors knew about this, and therefore they have no right to now claim that Mr. Salomon should be held individually liable for the debts of the company. All right, so yeah, so this is the first part of the question where we have answered many of the other parts as well. So you can see here the corporate veil is not lifted. It separates the company and the shareholders, and the fact that Mr. Salomon was not held liable for the for the debts of the shareholders of the debts of the company due to the unsecured creditors, that is the proof that the veil was not lifted in this case. And yeah, so we've already discussed the Erlanger versus this particular case, the distinguishing aspect of this. Now, formalism versus realism, again, many of you were not able to actually talk about formalism versus realism make a very good distinction. But anyway, you can see here littered throughout this case of this judgment are many instances of maybe I've extracted too much here. You can see here all the requirements of the Companies Act were strictly complied with, and that's all we care about. We don't care about whether this was a moral act or he was doing the ethically correct thing by conducting his business under the shield of limited liability. The court is not interested in all that. They're just interested in whether all the boxes were checked as far as what the law requires, and then that's all they care about. Okay, what objection? There is no word, and there is not a word in anywhere forbidding or even pointing against such a form of company. Right? That is, they have talked about this. Okay. So everywhere here, court cannot impose conditions not imposed by the legislature. The classic example of a very formalist approach to reading the law. Right? Unfortunately, in many cases, even not just in India, but even in the US, other countries, you see lots of cases where the judiciary is drifting from its well-defined role under the separation of powers doctrine. In many cases, like in the US, you have a very big problem right now with many judges who are issuing, because they don't like Donald Trump's policies, so they are issuing injunctions against his policies to block him. So he's been blocked many more times than the previous two presidents combined. So this is an example where the legislature is taking an activist role. This happens when you don't believe in formalism, when you have when you believe in realism. Okay, so these are all examples too. You can see that realism you see in India as well. many cases you see the judiciary also intervening with areas where they're not really concerned. Okay, like the judiciary in the case of the Rohingya immigrants, if you see, the Supreme Court actually said they took a very activist position. But strictly speaking, that's actually a policy decision. To let them in or not to let them in, it's a policy decision. Just like CAA, these are all policy decisions. So it's a policy debate. It should be a political position, but taken by different political parties. But the judiciary got involved in it and tried to tip their, put their finger on the scale. So these are all examples of departures from legal formalism. Right. Yeah, sole guide must be the statute itself. So there are many examples here. I'm not going to go through all of them. You can read them later on when I place that. Okay, so I think now we have answered the basic questions. Then I'll just try and cover a little bit into a little bit of the, so this just exemplifies formalism. All right, so let's now, yeah, so I'm going to try and cover a little bit of some of the other points which can be studied. Now this is a very interesting case because we can use this the facts of this case and the deliberations on this case to get into many areas of finance, and that teaches you how to look at things from an interdisciplinary perspective. Let's look at some of the other things. What is happening here? People are murmuring. You have to maintain discipline and be quiet until the end of the class. So we have covered, okay, here there's a concept of we can have what is called incidental learnings of finance. Okay, there's a term called haircut. Have you guys heard of this term called haircut? Haircut? No, not like that. Not that kind of haircut, but haircut is a term used in finance where, for instance, okay, if you have any case of, what secured lending is?
Yes, sir.
When you're taking a housing loan, the house is a security against, that is the collateral, we call it the collateral. Okay, so the housing loan is an example of secured lending.
Extra over the amount of
correct. Yeah, but let's be very specific. So the haircut is equal to, in this case, I've given you an example, I haven't given you a theoretical definition. So the haircut, the term that is used in finance, is when the value of the starting value of your collateral at the time of the loan is issued. Remember, this is only the starting value of the collateral, because you may take your housing loan today, the house may be worth say 100 million, okay, and then maybe after 2 years the house may be worth maybe 80 million. So we are only talking about the starting value of the collateral. So the starting value of the collateral and the amount of the loan, that difference is the haircut. Okay, so maybe I should not have given 5k, it's not very clear here, maybe we make it 7k, and then in that case the haircut is 3k. Right, so in order to give you a 7k loan, I'm taking an asset as collateral which has a value of 10k. So I'm applying a 3k haircut for you. Okay, so obviously if you're seen as a very high quality borrower, the lower the haircut, the smaller the haircut, the more high quality the borrower that you are. All right, yeah.
For example, a bank has this policy that the value of loan against the FD is calculated as a 10% on 10% margin.
Yeah.
Right? So for example, if I have FDs of about 1 lakh, I can take loan up to 90,000 or 85,000.
Yeah.
So what's that 15% or 10% is called there?
That is the haircut then. In that case, that is the haircut, right? So the haircut is always the starting value of your collateral minus the quantum of the loan that is sanctioned. That's always the definition.
Starting value would be 1 lakh, and because after 5 years there would be interest.
Yeah. So in this case, in the case of fixed deposits, the risk really for the bank is that the value of collateral might drop, like in the case of houses, which happened in the housing crisis which you had in 2007, 2008 in the US. So whereas for FDs, the collateral value can never drop; it can only increase, right? So in this case, yeah, that is basically the starting value. That's why we take the starting value. Okay, starting value minus amount. So this is one new term that you have learned. Okay, some other new terms that we can quickly cover. So what I will do, obviously we will not have time to discuss everything. So I will release 2 videos. One will be this video, and then I'll release a separate longer video which you can study if you want to learn about all the other different aspects of this particular case. All right. So one is this. The other thing we want to talk about is, as you can see, there's a concept of nominal capital. Okay, you understand what nominal capital is?
Yes, sir.
Nobody should get restless. We still have 4 more minutes. I don't want to see anyone getting restless. Okay. Nominal capital is what we call authorized share capital. So make sure you learn all these concepts. Okay, whatever is covered in the class is part of your syllabus. All right. So nominal capital is what we call authorized share capital. When you set up a company, okay, you have this nominal capital, which means
Maximum it can borrow.
maximum equity. That this is everything is written here. So I'm not going to, and all will be pasted into your notes. All right. Okay. Now, after you form the company, so this comes first. You form the company, and then you call people for subscriptions. Okay. Just like Kedarnath Bhattacharya was calling people like Gauri Muhammad for subscriptions. So you call people for subscriptions when they subscribe. After they have subscribed to the shares, right? So Mohit calls and says, "I want to buy 10 million worth of shares." So we make a note of that. Then when I issue the 10 million shares to Mohit, that is the issued capital. Okay. Now I may have issued 10 million shares to Mohit, but he may have paid up only 7 million. So in that case, the paid up capital is only 7 million if he's the only shareholder. Okay. Then the paid up capital is 7 million, but the issued capital is 10 million. Okay. So in this case, and so this is basically this is what we mean by subscribed, issued, and paid up share capital. Okay. We have already discussed limited liability. Okay. So what we'll do, very important concept. Please make sure when I release the longer video, please make sure everybody here understands. I'm going to spend time on it in the class. We don't have the time. Make sure you understand that net worth. You know what net worth is?
Yes, sir.
Make sure you understand that net worth is a residual.
Assets minus liabilities.
Yeah, total assets minus outside liabilities.
External liabilities.
External liabilities is equal to net worth. It's a residual concept. What is residual? It means
Leftover.
first I eat, whatever is left over, only that you can eat. Okay. So if I eat everything, you have nothing. Okay. All right. So in this case, yeah, we'll give you 1 minute grace, 10 seconds grace. Okay. You can go now.